This is my approach to forced compromise and mediation. It's the best approach possible. It works every time. I'm going to talk first about the resistance to ADR. And this is a global paradox. I'll tell you in a minute why I have those two spray containers there. It's a global paradox. All around the world, I go to conferences, and at every conference, people are scratching their heads saying, why is mediation not taking off? It's a wonderful product, it's cheap, it's fast, people aren't buying it. Well, I wrote an article 10 years ago now in which I compared mediation and litigation to two stain removers that you could buy in a supermarket. On the left, you have litigation. You buy it at the supermarket, stain remover. Everyone who's used it says it's terrible. It takes ages to get rid of the stain. It only gets rid of the stain in less than 50% of the cases. It's very expensive to use. It takes a long time, and sometimes you have to try it again. And when it fails, you have to try it again. And most of the time, it leaves a very unpleasant smell behind. Don't touch it. Next, on the next shelf, is mediation. Everyone who's used it says, it's amazing. It's fast, it's cheap, it's effective, it removes 80 or 85% of the stains on the first occasion, and it doesn't leave a nasty smell behind. It's amazing. Now, in a supermarket, litigation, the stain remover litigation, would be out of business. Nobody would be buying it. And mediation, people would be queuing up to buy it. In the real world, it's the opposite. Why is that? Why is such a good product not being bought by the public? We've heard today people complaining about the cost of litigation, about the time spent in litigation. And yet here is a product that saves time, saves costs, why aren't they using it? So I'm going to try and explain it a little bit. What do parties need when they are in dispute? When a party is in dispute, generally speaking, they are in a dispute because they feel that they are a victim of an injustice. If somebody has broken a contract, they are a victim of that injustice. If they are being accused of breaking a contract without foundation, they are again the victim of an injustice. If somebody is negligent, that is an injustice. If you are wrongly accused of being negligent, that is an injustice. So people will enter into a dispute as a victim of injustice. They each see themselves, their company, their organization, a victim of injustice. And victims of injustice need three things. Firstly, they need vindication. They need to be proved right. Companies need to prove that they are in the right, that they didn't break a contract, or that the other side did break a contract, or they weren't negligent, or the other party were negligent. We need to be vindicated. We need to be able to say, I told you we were right, I knew we were right, and now we've been proved we were right. The only person who can prove that we are right, we think, is the judge. And we have this wonderfully naive view that the only person who will see that I'm right is the judge. My lawyer can tell me I'm wrong, my family can tell me I'm wrong, my experts can tell me I'm wrong, my board of governors and trustees can say I'm wrong, but you wait. You wait till I get in front of the judge, he or she will see that I'm right. And if he doesn't, well then he's a wally. We'll go to the Court of Appeal. And if they don't, well they're all stupid, we'll go to the Supreme Court. And so it goes on. We have this wonderful idea that we need to be proved right. And if we're not proved right, and if we don't have the opportunity to prove ourselves right, it's a sign of weakness. Why should I compromise when I'm right? Why should I say sorry when I've done nothing wrong? Why should we sit around the table and give way when we haven't done anything wrong? So it's a sign of weakness. And when people select a mediator, when when they select an arbitrator, they are looking at one thing only. Which mediator is going to see that I'm right? Which arbitrator is going to see that I'm right? That's all they're worried about. They don't care about their success rates. I am never asked how many mediations have you done, how many times are you successful. If my CV says something about the area of dispute, I will be chosen for that. Because they think, okay, I've got a dispute with my bank, he seems to know something about banking, he will see that I'm right. So that's what the parties need. They want revenge. If I have suffered injustice, I want the other party to suffer similarly or worse. If I've been hurt economically, financially, emotionally, physically, I want the other party to be hurt as well. And most often, the way I think they will be hurt most effectively is in their pocket. I'm going to sue them for millions. That will hurt them. There are jurisdictions, some of us come from them here, where it takes 10 to 15 years to get a case to a resolution in court. You're not doing that for compensation. You are doing that to punish the other party. They're going to have this case hanging over them for 10, 15 years. I'm going to feel good about that because I'm punishing them. They're going to hurt. So we want revenge. We want sufferance. It's primordial. There it is in the Bible. An eye for an eye, a tooth for a tooth. If we've been hurt, we want someone else to be hurt. And we think that in court, in litigation, that's the best way. Can you imagine the judge sitting there saying, you are wrong, you have been bad, you have been good. Wonderful, wonderful revenge. Humiliation, public humiliation. There it is in the newspapers, they have been proved wrong. And of course we want a remedy. We want something done about it. And the problem is that in litigation, the remedies are very limited. It's money, or maybe an order to do something or to stop doing something. That's all. In mediation, the remedies are wide open. You can agree anything. I had an employment dispute between two heads of departments in a huge bank. And one of the terms of settlement between the head of one department and the head of the other was that one head would use lifts number 1 to 3 when going up to their office, and the other head of department would use lifts 4, 5, and 6 to go up to their office, so that they never had to stand in the same lift going up to their offices in the morning or in the evening. Can a court order that? No. But this was very important for them, very real. So in mediation, the remedies are wide open. So what are we doing when we're litigating? What is the basis of it? Well, we are all in the business of persuasion. Every litigator and every mediator has to be a persuader. What we are trying to do is to secure an attitude shift. When parties come into a dispute, they come in with a position, an attitude. This is what's happened, it's wrong, this is what I want, this is what I think of the other party. So if there's going to be a resolution, either in court or in mediation, that attitude has to change. There has to be an attitude shift. Either I change the view about myself, maybe I contributed this, maybe our company wasn't as good as we could have been. Or we change our dispute about the other side. Okay, well now I understand why that company did that. Well, maybe I look at them in a slightly different way. Or we look at the dispute in a different way. Maybe it's not so important. It's not the be-all and end-all, as we say, that I win this dispute. Again, it's a wonderfully naive concept by people in litigation. If I win this case, the world will be wonderful. The life will be rosy. Everything in the garden will be wonderful. And it's not. So we need a change in attitude to ourselves, to the other party, or to the dispute. The problem is that there is no common sense. We were talking yesterday about common sense. And the problem is that there is a lot of sense, but it's never common. The parties do not see the position from the same perspective. And this is, again, a deeply philosophical concept, that there is no such thing as objective truth. Each party's approach, each party's belief is the only real truth. And one party will believe that their truth is the only truth, the other party will believe that their truth is the only real truth. And they have complete contempt for each other because they can't understand, why can't you see my truth? This is the real truth. There was an American comic called George Carlin who encapsulated this beautifully. He said, have you ever noticed that when you're on the freeway, the people driving slower than you are idiots, and the people driving faster than you are maniacs? In the world of conflict and dispute resolution, we are walking through a world of idiots and maniacs. One party says the other side are maniacs, they're crazy, they're off the planet, and they say they're idiots, they're stupid, they're unintelligent. And this is the problem. Each party sees the other from a different perspective. And we need to get them to change that position. The real problem is that logic doesn't work. We cannot do it through logic. It took me 35 years as a lawyer to realize that logic doesn't work. Because when you go to a court, when you go to the Supreme Court, you've got the top brains on each side. Each side's lawyers, their experts, their counsel, all saying, this is our recollection, our understanding, our interpretation of the law is correct. It's logical. And the other side is saying the same. I used to draft letters, correspondence, which we called letters before action, where in my letter I would set out in beautiful numbered paragraphs with impeccable logic, unassailable legal correctness, why my client was right and why their client was wrong. 14 points, numbered paragraphs, this is why we're right, this is why you're wrong. And we would send these letters out, again, in the beautifully naive view that the other side would read it and say, oh, my goodness, we never looked at it like that. They must be right. It never, ever happened like that. I don't remember one occasion in 30-odd years of writing this correspondence where I've seen a letter from the other side saying, you know, you're absolutely right, we cave in. On the contrary, what happened was that they would say, all your 14 points are rubbish, here are our 28 points, which are the real truth and the real correctness. So what we were doing was pushing parties further and further away from each other. Crazy. If lawyers are trying to get a resolution, how crazy is it to send correspondence that simply drives people further apart? And we would do it day in, day out, week in, week out, and we're still doing it. And somebody said that one of the signs of insanity is to do the same things over and over again in the same way, expecting a different result. That's what lawyers are doing all day long, I'm afraid. It's shameful. So logic doesn't work, and we need to get parties down from an emotional state, because it's the emotions that prevent logic from working. When we are in an emotional state, we are not ready to listen to reason. So as mediators or as litigators, as lawyers with our parties, we need to move our clients and the parties off that high emotional platform to a platform where they are ready to listen to reason. And I'm going to show you a clip now which will demonstrate how deeply embedded these emotional responses are in our psyche. Can you hold on one moment before you play it? This is an experiment done by using two capuchin monkeys. They are put in cages side by side, and they have a task. In return for a rock, giving them a rock, they get a cucumber. Now, cucumbers are Very nice for capuchin monkeys. Then the capuchin monkey on the right gets a grape. Now, grape, that's a different matter. Grapes are wonderful. They are luxury. And the first capuchin monkey sees the second one get a grape, and when he gets a cucumber again, you'll see the reaction. Okay.
Getting grape, and you will see what happens. So she gives a rock to us, that's the task, and we give her a piece of cucumber and she eats it. The other one needs to give a rock to us, and that's what she does. And she gets a grape, and she eats it. The other one sees that. She gives a rock to us now, gets again cucumber. She tests the rock now against the wall. She needs to give it to us. And she gets cucumber again.
Okay. So, these are monkeys. They are not conditioned like us to go to work, come back, have wives and children and cars and have to commute. They are really basic natural creatures. And for a natural creature to sacrifice food is extraordinary. For that monkey to say, I'd rather go without than let that bastard get a grape. Now, do we see that in our conflicts, in our everyday disputes? It runs through every single dispute. If one party feels that the other party is getting away with something, they will not settle. They will not resolve their dispute. They will fight until they get some justice, because that's unfair. That's an injustice. And when that other party is getting a grape because they are corrupt or because they have done something underhand, it's even worse. And we see that in everyday conflicts. People are happy with their position. They're happy with their company car, their desk in a right place in their building, until the guy next door gets a better company car, gets a nicer desk, gets 2 computers instead of 1. Then their car, their space is no longer acceptable. And that is what's happening in conflicts. We will not resolve our conflicts whilst we remain a victim of an injustice. And we will fight as hard as we can to get away from that sense of injustice. And this is the problem with litigation, is that we are constantly looking at rights and obligations. We are in a rights-orientated society. We have the Human Rights Act rammed down our throats every day. You've got rights. If you've got rights, other parties have got obligations. As we all know, mediation looks at needs and interests. Maybe you are entitled to 2 million euros, but do you really need 2 million euros? Is that really in your interest to get it? So we look at needs and interests, and we look at what's in your best interests, and what are your needs or wants. And this is some of the psychological problems. Needs and wants. A need, if it's a true need, is non-negotiable. If you really need something, you can't negotiate about it. If you want something, if it's an aspiration, if it's a hope, if it's a desire, then it becomes negotiable. And what parties in dispute often get wrong, they conflate needs and wants. I must have an apology. Is that a need or a want? It's certainly not a need, but it may be a very strong want. But that can be negotiated. I need enough money to keep the roof over my head. That's a need. I need compensation, otherwise this company goes under. That's a need. So we need to look and differentiate between needs and wants. And that is something that in mediation, the mediator can do. Very difficult to do in litigation. I'm going to talk about the Golden Bridge in a moment. But one of the problems, one of the real blockages to any sort of dispute resolution is self-esteem. We all have self-esteem. We have personal self-esteem, we have corporate self-esteem, we have national self-esteem. Just look at what's happened in the last year about people promising to make our country good again. That affects our self-esteem. I'm going to make you feel good again. That affects my self-esteem. So we all have a need for approval. We need approval from our board of directors, we need approval from our employers, from our employees, from the other party. Everybody needs approval, and everybody has self-esteem. Now, that need for approval has an opposite effect, and that's our fear of humiliation. We have a complete aversion to humiliation, understandably. Some Italian scientists were able to discover through neurological advances, because they were able to trace the circuitry of the brain, what happens when we're humiliated. When we are humiliated or put down or made to feel ashamed or just criticized, the same part of the brain lights up as physical pain. So social pain is interpreted by the brain as physical hurt. That's why it hurts us to say, I'm sorry. That's why it's so difficult for people to say, I'm sorry, because their brain doesn't allow them to do it. It's like putting their hand in the fire. You have a natural aversion to putting your hand in the fire. But humiliation is something that we are all trying to avoid. And corporate humiliation is just as powerful. National humiliation is equally powerful as individual humiliation. A little while ago, they did a survey on what people's greatest fears were. And people's greatest fear was not the fear of death, not the fear of flying, but the fear of speaking in public. Now, why should the fear of speaking in public be so terrifying? It's terrifying because each person in that audience has the capacity to humiliate me. Every person in that audience has the capacity to look and listen at me and say, this guy's a wally. Now, 100 people, 200 people, 1,000 people in the audience, that's terrifying. And we don't like it. So we all have this need to avoid humiliation. And this is when I talk about the Golden Bridge. When parties in mediation say to me, Paul, I don't see why we should compromise any further. We are going to win in court. Why should we give way? I tell them about the Golden Bridge. The Golden Bridge was a concept written about 400 BC by a Chinese military strategist called Sun Tzu. And he wrote a treatise called The Art of War. And in The Art of War, one of the things he said was, a wise conquering general is one who builds a golden bridge upon which his defeated enemy can retreat. In other words, give your enemy, your defeated enemy, some dignity in defeat. Because if you don't, if you surround your enemy and give them no way out, what will they do? They will not give up. Because their self-esteem won't allow them to give up. They will fight back and there will be bloodshed. So he said, give them a golden bridge, build them that golden bridge. And in disputes, in litigation and in mediation, I'm always telling parties, give them something. Give them something which can let them say, okay, not great, not ideal, not what I really wanted, but it's something. Something that allows me to go away and say, okay, I got something out of it. So the golden bridge is really important in our need to understand parties' approach to humiliation. And it's one of the reasons for impasse, for deadlock, when parties reach deadlock in negotiations, it's because their self-esteem has gone as far as it can, and it won't allow them to go further. It won't allow them because anything further appears like humiliation. And most importantly, we all have a need to be valued. The thing that drives litigation is that we are not valued. If somebody breaks a contract, that indicates to us they don't value us. They don't value our company enough to comply with the contract. If we accuse another corporation of breaching a contract and they don't immediately say, "You're absolutely right, we're terribly sorry," that again affects our self-esteem because they don't value me enough in order to admit that they're wrong. A lot of the things that push our buttons in everyday lives is about not being valued. If somebody's late, that irritates because we think, hang on, who do they take me for? Why are they late? In the workplace, if people are untidy and you have a value around being tidiness, why are they untidy? Don't they value me or the company enough to keep their room, their desk, their office tidy? These things irritate us because it affects our self-esteem. We need to be valued. When people don't respond to emails quickly, we feel undervalued. We think that they don't respect us. We don't like it. My wife used to get really upset when I would put the coffee mug into the sink and not directly into the dishwasher. Or when the kids would just step out of their clothes, leave them in the middle of the floor and walk away. Why? Because she said to herself, why is it assumed in this house that I'm going to go around picking up the coffee mug, putting it in the sink, in the dishwasher, or the clothes from the floor? She feels undervalued, and she has what we call an amygdala hijack, and it's not very pleasant. She gets very upset. So we need to be valued. And one of the ways of being valued is to be heard. I've just got 2 more points. We all want to be heard. When we are not heard, we are not valued. If we don't have a voice, we don't feel valued. When a company is forced to litigation, they are forced to litigation because they say, they're not listening. They don't seem to understand. They're not listening to us. What can we say to make them understand? We'll sue them. Being heard means being valued. And finally, we have a need for control. Again, this is a deeply philosophical concept, that our need for control is one of our coping mechanisms for uncertainty. We live in a totally uncertain world. Everything in this life, in this world, is uncertain. Even death, which is the only certainty, is hedged around with all the most awful uncertainties. We don't know when, where, how, or why. How do we get up in the morning with that level of uncertainty in the world? Well, we do it by maintaining some sort of control, by maintaining some sort of boundaries. When we are out of control, we say we're outside our comfort zone. When we are outside our comfort zone, we are in a situation in which we don't feel entirely in control. And when people are litigating, they are trying to regain control of a situation which they feel they have lost. And we do that all the time. When we slam a door and walk out, we are trying to regain control of a situation which we feel we've lost. When we shout over somebody, we are trying to regain control of the conversation because we feel we've lost. We are constantly trying to regain control. That is what's happening in litigation. That's what's happening in mediation. Each party is trying to regain control of the situation which they have lost. And when they've lost that control, they feel bad. It affects their self-esteem. So these are just a few of the psychological aspects of litigation and mediation. And if we follow them and understand them, then we won't feel like that, but we'll have that. Okay.
Thank you very much, Paul. Thank you very much, Michaela. Now we have 10 minutes for questions, suggestions, comments. wherever from the audience.
Thank you very much, Michaela and Paul. Just two questions and a possible comment. Michaela, you made reference to mediation for resolution of family disputes. If I had you right, in Italy, and I was wondering how far in terms of scope of disputes within the family can mediation as a mechanism be used to resolve. If I heard you right, you made a reference to mediation being a tool to resolve family disputes. Is it all family disputes? Or are we talking about possible divorce matters, or are we talking about domestic violence within families? I just need some clarification on that. And Paul, don't know where to begin, but to say fantastic insights on your presentation. So my takeaway is this is really a human problem on the one hand, and in some respect also an institutional one, because you do have, and I think you made that point when you say not only individuals feel the possibility of being humiliated, but also imagine where countries or corporations, and it's indeed amazing, because you do find occasionally, and I've made that point, that corporate entities would typically tell you, you know what, we may not really have a good case, but because we see the system is slow and we think it's a David and Goliath kind of fight, you know what, just keep fighting. And it's so sad, but this moves from one in-house general counsel to another. Now, forgive me, I may not complain so long as you pay my fees, but it is a problem, and I suspect it would really require significant attitude change. And then finally, what's a wally? Thank you.
Divorces, basically divorces, to the first question.
In the UK, family mediation is very, very popular. In fact, even more, to some extent, more popular than, or more used than in commercial civil mediation. And it's used throughout, in divorce, in children, in property disputes. There is argument as to whether you can use it with domestic violence. A lot of people say, no, one says domestic violence, you can't. I personally say that's the one place where you really need it. But there are different views. The other question about, corporate self-esteem. I mean, self-esteem is extraordinary. If England win a football match, the whole nation's self-esteem, everybody is lighter. When they lose, you know, everyone, the whole country goes down. It's extraordinary. And so you can imagine in a company where they know that there is litigation, and their reputation, their trademark, their standing, their credibility is under attack, it affects everybody. And a Wally is an idiot.
It works. Oh, this is actually a follow-up of the same question. Your analysis and analogy for the mediation and court decision are all true if this between two individuals. And then with those super large company where there's a full lack of personality sometimes, because you always hear those, your call is very important to us, but please hold for another 2 hours. And then when I was dealing with British Airways, like this time coming to this meeting, there was like 48 hours delay. And each time you have a discussion with the customer service or whoever, at personal level, they will fully understand your position, but then they can do nothing because the system, either the system will not allow them to do so, or the computer will not give them the procedure to deal with your inquiry or to show the empathy, the sympathy or whatsoever. So my question is really, when the company or those corporate became so large, became such a machine with no human factors, but then a huge structure designed to squeeze the end user, competing with each other, and then every director for a public company is more of a discharge their duty as a director. And then does those, like those monkeys' character or any human being's character do reflect in the company as a corporation, or is more logics and common sense will play? Will that make any differences?
Yeah, I mean, it really comes from the top. This idea that we need to understand people. I'm afraid in the UK, customer relations, consumer complaints departments are absolutely abysmal. They have no idea how to handle a complaint. They simply say, as you say, you know, it's not our fault. That's not what the person wants to hear.
By the system.
Okay, but there are ways of dealing with that. You have to diffuse. Again, logic doesn't work. It's no good saying, look, I'm sorry, my hands are tied by the system. That doesn't work if a person is angry, if they've been stuck in an airport for 48 hours. That's not what they want to hear. You have to do it in another way. This is a great example of where logic doesn't work, and simply trying to explain to them why the system doesn't allow this. That is not what they want to hear at that moment. They have to be dealt with differently. And I do a lot of training of complaint handling in banks, in universities, in corporations, and it's totally different. And this is the problem. These are all counterintuitive. What you want to say to the person is exactly the opposite of what you should be saying. You want to say, look, it's not my fault, get a life. You know?
It's very difficult to run the companies because you need standard and you need to a systematic approach to all dealing with all those complaints. And then everyone is just having this I'm just doing my job attitude, which eventually wipe out all the personalities, which should be contained in a large corporation. That's why I'm saying if this is a dispute between two super large corporations, those two general counsel can be good friends at personal level, but then at corporate level, probably it's more of a logics or rather than personal attitude or emotion.
Yeah, I mean, somewhere in that dispute there is emotions, because if there were no emotions, if there were no, as I think somebody said, it's just number crunching. If it were just number crunching, there would be no cases going through the courts. None. Because they would sit round the table with a calculator and do number crunching. What prevents that from happening, from the blockage, is somewhere along the line, whether it's at the top or in the middle or at the bottom or one of the directors, somebody's saying, hang on a moment, I'm not going to accept this. And that's where the problem arises.
So in that sense, mediation has no future as a human character of a company, because everyone wants to have a justice. No, it's just come.
No,
so then, there constructive or any hope for mediation if people just want justice, and then mediation, as you said, lacks what people need in terms of justice.
But the mediator, the beauty of the mediator is the mediator can explore, what does justice mean for you? What does justice mean for you? How can we achieve that? How can the other side achieve that? If Kim Jong-un says, I want world domination, a mediator would say, okay, fine. How can we achieve that for you in some other way? What is it good? Why is world domination so important for you? What are you trying to achieve? What are you hoping for? And we can then work out some other way of doing it.
All those sanctions against him.
Yeah.
That's it.
If I can add something to that, I also think it has quite a bit of education on it. I mean, we are educated to go to the teacher if someone is disturbed, or go to Papa or Mama, or to the court. And if we would be educated in trying at least to solve our problems since we are kids, to talk and to try to understand why he did what he did, or she, and why I did what I did, I think it would change. It would change a little bit. I think it's mainly a question of education, and at least I am not educated to solve my own problems. I went always to my mother or my father or my teacher to say he is kicking me and he is disturbing me and I have this sense of going to the court. But I think if we try to educate these younger generations on trying to solve your own problems and to understand a little bit why others do something different to you, this can change.
Yeah.
And this can change also, at least this will go in some point in the future, it will go into the system. And one day the system will not allow to say things that now it's for sure you get from the system. This is what you say 2 minutes ago. The system does not allow this. Maybe the system should be changed according to our mentality. But first we have to change our mentality.
And first we have to understand the powerful drivers. I mean, can you imagine telling those capuchin monkeys, now look, let's sit round the table nicely and discuss this. That monkey was shaking that cage with rage. Now, while that monkey is in that state, there's nothing you can say to them to say, now look, come on, let's work this out. They won't. You've got to diffuse that emotion. You've got to understand it, empathize, and get them into a state where they can start thinking things in a different way.
We've got 5 minutes left.
Yes. Paul, just a thought, and I would want to get your comments or idea on this. Based on my experience, mediation is successful in some of my cases if I already have some leverage. So if the other party feels that going on to a litigation would be a useless exercise for him, sometimes they settle. And in my experience, I don't know, that's why I want this on the floor. In my experience, if they are on the same level, because they have their own self-esteem, they don't want to mediate. Because they think, I'm much better than the other. But the very moment you have some advantage, and I've seen this, most of my cases that were settled, the very moment I have a little advantage, they sit down, they think, and try to realize that it's useless to go on to a litigation. That's one. Another point. Another one, don't you think that the lawyer likewise has a duty to clearly explain the situation to the client? Because sometimes lawyers communicate in a telegraphic manner. Or maybe the lawyer doesn't want the case to be settled. So he doesn't explain it in a manner that the client should understand.
Yeah. That leverage you talked about is what I understand to mean by the shift of perception. That's what the mediator is trying to do. Change the perception. Is going to court really going to help you? Or are there things that you are worried about? Has the other side got some leverage? It's changing your perception. If you can't change a perception that I'm going to do better by going to court, you won't settle. If that attitude remains, I am sure I'm going to do better in court, there's not much you can do about it.
Again, if I may, just a little addition to that. I think that is where some mediators would have to also work on.
Yeah.
Because to some, they just go through the process. Like in our country, it's mandatory.
Yeah.
They just go through the process. And in my experience, unless I get the leverage, they won't sit down.
And to what you say in the second point, I completely agree. In Spain, or I think it's worldwide like this, the lawyer is the person who advises the way to better solve your problem. So as a lawyer, I think you have the duty to know that there's mediation, that there's arbitration, that there's litigation, and then you have to know this alternative dispute resolution methods in order to be able to tell your client which is the best way for him to solve his problem. From an ethical point of view, I think we are obliged and we have the duty to know what is possible to do, what are the products on the market for our clients to solve their problems. If we skip this, we are really not good lawyers for our clients. There was a Jennifer.
Paul, a question for you. when you were saying, it's all about feeling valued and self-esteem, how can you convince a party that they do not need an apology in that, in that scenario?
Well, again, you wouldn't set yourself the task of convincing them. You would explore what it is about the apology that's so important to them. And once you understand what is so important about the apology, then you can address it. Because an apology can have all sorts of things. I want them to grovel. I want them to be humiliated. Or I want them to take responsibility for what they did. Or I want them to show me respect. These are all different things. And if a person says, well, I want them to show me some respect, is there any other way they can show you respect besides just saying the word sorry? If you want them humiliated, is some financial compensation maybe an alternative? So you explore, but you wouldn't say, now come on, you don't really need an apology. Because they say, yes, I do.
Yeah, Sonia, I was only just going to address the point you raised about the ethical issues around a lawyer who doesn't properly advise. I think some of the challenges in most jurisdictions is there are no significant sanctions against lawyers who are expected to take certain preliminary steps before a matter proceeds to court and gets bogged down in protracted long litigation. So when you come from a jurisdiction where you know that you would not be penalized and possibly an audit of your matter would not be undertaken either by the local board, by the local bar association, or by other regulatory body, there's always no obligation, it would appear, on you to do what is right. And I suspect that is some of the challenges that one may need to contend with.
There's a question over there.
Anything else?
Yeah, really for Paul, just from a mediation perspective, how many kind of percentage-wise, I guess, mediations do you see that are, excuse me, really just companies needing a third party to just give a view that they haven't seen before? I know the mediator shouldn't really be involved, but I've had quite a few experiences where the other side's just needed somebody other than us to say that this is a sensible solution.
Again, I'm very reluctant to be evaluative. I'm very reluctant to say to party, well, I think you've got a weak case or whatever. If both parties want me to evaluate, if they say, look, we're not getting anywhere, it may help if you give us your view. If both parties say that, then I will discuss with them how we can do that, whether it's binding or non-binding, etc., whether they just want my opinion. But yes, there will always be some blockage, some emotional blockage. And if I, as the mediator, can unlock that blockage by saying, look, I think this is my view, then I will do it. That's my role, trying to resolve, trying to remove the psychological blockages that have prevented two commercial organizations, two commercial, profit-conscious, business-orientated, money-sensitive entities locked in conflict. It's crazy. It simply is uncommercial, and there is something blocking it. And my role as a mediator is to find what that blockage is, whether it's self-esteem or whatever. And if it needs an opinion, I will give it to them.